I didn't.
Sorry, if you could start over, Madam Chair.
No problem. Oh, there we go. Okay. All right. Good afternoon, everyone. This is the meeting of the Sentencing Guidelines Commission for July 28th, 2022. We are doing this as a hybrid meeting as per state, which we're allowed to do under state law, by giving proper notice in advance. I will just say that we have a couple of members that we're still expecting to arrive. So we're not up to full strength yet with the commission, and we're hoping that a couple of folks will filter in as we get going here. But let's start with what we have, and I'm going to ask Nate to call the roll.
Roll call, Estrada.
Present.
Estrada present. Hansi.
Present.
Hansi present. Ibrahim. Ibrahim absent. Knudsen.
Present.
Knudsen present. Ladd.
Present.
Ladd present. Larkin. Larkin absent. Middlebrook.
Present.
Middlebrook present. Moore. Moore absent. Morath.
Present.
Morath present. Schnell. Schnell absent. Chair Mitchell.
Present.
Chair Mitchell, there are present. Madam Chair, there are 7 members present, 4 members absent. And I should say I was expecting the absence of Officer Ibrahim and Commissioner Schnell.
All right. So with 7 present, we do have a quorum today at this point, and we'll recognize anyone else as they arrive. The next thing is to approve the agenda. I just actually want to make one adjustment to the agenda. That item 2 is the welcome of our new member, Officer Ibrahim, that he has a training today, so he was not able to attend. We're going to move that to next month's agenda unless there's any objection. I mean, there shouldn't be any objection to that. And then I'd actually ask for advice from the members that are present, whether we should consider, so number 4 is approval of the draft minutes from June. We also have minutes from the roundtable last week. And I guess my question to the commission would be, would you like to add that there, approval of those minutes as well, or would you like to wait until our next minute and do all the July approvals at the same time? Does anyone have a thought on that?
And Madam Chair, I didn't get the meeting minutes from last week to you
Yeah.
a week in
You
advance.
haven't had it for a week, so it's totally fine if we want to delay.
If I might, Madam Chair, I think I would prefer to wait just so that there's an opportunity to
Sure.
take a look at those. I mean,
Okay.
are we on any time crunch to get those today?
Nope, we
Okay.
sure are not. We just have them, so I wanted to see if people wanted to roll that into number 4. Okay, so with that, then the change to the agenda would be we're just striking number 2 for today and moving that next time. So with that, I would entertain a motion to approve the agenda with that change.
I'd make that motion.
Commissioner Ladd moves to approve the agenda of striking number 2. Do we have a second? Commissioner Middlebrook seconds. Any discussion on the agenda? Okay, with that, Nate, please go ahead and call the roll for that.
To the Ladd motion to approve the agenda as revised, Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim? Ibrahim absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin? Larkin absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed, and obviously Justice Moore is now present.
Yep. Great. So we're up to 8. Awesome. All right. Next item on the agenda is approval of the draft meeting minutes from June 9th. You have had those for at least a week, but possibly 2 now. I would entertain a motion to approve the minutes from June 9th.
So moved.
Commissioner Moore moves, and I think I heard Commissioner Estrada second.
Yes.
All right. Any discussion on that motion? Hearing none, let's go ahead and read that off.
to the Moore motion to approve the June 9th meeting minutes. Estrada?
Yes.
Estrada, yes. Hansi? Hansi? Ibrahim? Knudsen?
yes,
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin? Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell? Chair Mitchell?
Yes.
Chair Mitchell, yes. Hansi? All right. So Madam Chair, there are 7 votes in favor, no votes opposed.
All right, with that, the minutes are approved. Okay, so item 5 on the agenda is continuation of the sex trafficking and prostitution review. And I'm actually going to turn over to Nate to lead us through this piece.
Thank you, Madam Chair. Just for background for everybody, we are currently undergoing a legislatively mandated review of how the sentencing guidelines treat sex trafficking offenses, which has been expanded based on some advice from the proponents of that legislation to include also some prostitution offenses as well. Back when the commission looked at this back in 2009, they didn't rank prostitution offenses on the sex offender grid, which is something the commission discussed whether it should be done or not back in May as part of this current review. One of the reasons the commission did not take that action in 2009 was because of some advice from the Advocates for Human Rights. We are pleased to have today Robin Phillips, the executive director. We also, Michelle McKenzie was also intending to be here, but she had a schedule conflict, so it's just going to be Robin today, unless you have other people you'd like to bring.
Yes, and Karen Long will be with us as well.
And-
Karen Long's a former staff attorney with us and former prosecutor, current volunteer.
Oh, super. Would you mind having a seat at the table just so that cameras can get you? Actually, anywhere around the table would probably be fine. If you sit in the front row, it might catch the back of your heads. So,
Wait,
That's fine.
which is the front row?
well, in that row,
You want us
Oh,
to sit
so
back over
maybe over
here
here.
is better?
That might be better.
yeah, it might be better on the side, just for camera work purposes.
Thanks.
I don't know where the camera is.
And Karen, I've known you in many roles. What role would you like the minutes to identify you in?
I'm here as a volunteer with the Advocates.
Okay, super. All right, so Robin, I told you I had 3 questions, and I also warned you that the commission's very free to ask you any questions of their own, but I just thought we could get the ball rolling with my 3 questions.
Let me just to ground it for everybody. I think the one thing you didn't touch on this time is when we were going through the prostitution review, you pulled out the minutes from the last time that the commission discussed this. And the Advocates for Human Rights were here then. And we're actually advising the commission that that we should delay the consideration of putting these items on the sex offender grid because there were concerns about unintended consequences for people who are victims. So anyway, so the commission did follow that advice at the time, and there was an anticipated legislative action, as far as I understand, that may not have materialized that year as well. So you can fill us in. But I just wanted to ground everybody that one of the reasons we asked you back was because that was very persuasive information for the commission to take into account at the time. And so we were hoping that you could tell us, has the landscape changed and are the considerations different today? And I know that Nate gave you some specific questions, so I'm going to let him ask those questions. I just want to make sure we have the framework as to why you were invited today.
Right, thank you.
And the first question, thank you, Madam Chair. And the first question is really, before we get into the specifics, just a general question. If you could please introduce yourselves and tell us about the Advocates for Human Rights and the work you do in the areas of sex trafficking and prostitution.
Sure. The Advocates for Human Rights is an international human rights organization based here in Minnesota. We represent victims of human rights violations, and we work locally, nationally, and internationally to change systems and conditions that cause the human rights abuses in the first place. We develop partnerships and mobilize volunteers because we believe everyone has the power and responsibility to advance human rights. We've been working on issues of human trafficking for more than 15 years, including both sex trafficking and labor trafficking. And we published the Sex Trafficking Needs Assessment for the state of Minnesota in 2008. We'd say we're very happy to see the advancements in the treatment of trafficking victims and the understanding of prostitution offenses since 2009, and we really appreciate the opportunity to provide input today. Thank you.
Thank you. And the second question is more specific, kind of following up on what Chair Mitchell was just saying. In 2009, the commission did consider ranking prostitution offenses on the sex offender grid. And at that time, the advocates for human rights asked that the commission delay changing the sentencing guidelines regarding Minnesota Statute 609.324 until after the 2010 legislative session, out of concern that such changes might have unintended consequences for victims of sex trafficking and for prostituted individuals. At least that's how it came out in the minutes. The commission did delay such action. And my question for you is, do the advocates still have concerns that such changes would have unintended consequences for sex trafficking victims and prostituted individuals?
Yes, and there were amendments to the statute that separate the purchase of sex and trafficking offenses from selling sex, and that has gone a great way to alleviate our concerns for the negative unintended consequences on victims. Your briefing paper points out the possibility of a problem if the purchaser is underage. And so we request that you include commentary that particular situation where the purchaser is underage and not the person selling sex, it's not intended to address that because it doesn't have the same predatory intent. And that also we suggest that you highlight in the commentary the possibility that trafficking may be involved in any transaction regardless of the age of the purchaser, and prosecutors should consider the totality of circumstances when considering charges. But again, the changes I think have greatly addressed our concerns.
All right. I mean, just to follow up on that, some of the actions of the sentencing guidelines are mechanical. I mean, they're automatic. So if an offense were, and we don't believe that it's necessarily common where the purchaser is underage and you know, that's what we refer to in the paper as child prostitution offenses. Typically, that appears to be an adult having or seeking to have paid sex with a child, but it could be the other way, where the purchaser is the child. If the commission did make this change to move the offense to the sex offender grid, that would apply to all cases, including the cases where the purchaser was the child, and that would mean that the consequences of having an offense on the sex offender grid, which include more severe sentencing for repeat offenders, I guess that's probably the primary one, would accrue to that offense automatically, regardless of what the commentary says. So, I mean, does that fact change your answer at all?
We talked about it at length, and I think that it's not necessarily strong enough to override making these changes. Do you want to add anything?
Right, we just had the conversation that these offenses, you know, trafficking offenses as well as the patron offenses for the purchasing of sexual acts, they tend to have, you know, they can at times have consequences for people who we also would identify as victims. And so there can be overlap in these cases in ways that don't apply to other criminal situations. And so in understanding that your commentary is commentary, and that the guidelines are going to be the guideline sentence absent reasons to depart, we had just talked about the idea that you could make a note that, that advocates recognize that there can be overlap in these cases, and that if the person charged is younger than the other individual, that might be a situation that would warrant special care in reviewing how to handle it.
And then my final question was, and you've already indicated that you had a chance to read the May 6th staff paper called Ranking Prostitution Offenses on the Sex Offender Grid, which for everybody's information is part of today's meeting materials as well. And my question is, do you have any comments or concerns about the paper or the staff recommendations that are made within that paper?
I have a few comments. We agree with the statement that there is no statutory support for differentiating between the purchasing the act and the agreement to purchase the act, and differentiating between sexual penetration and sexual contact. We agree with that. But we disagree that there's statutory support for separating attempts to buy sex from children to attempts to buy sex from undercover police posing as a child. The amendment to the statute the statute was amended to specifically address that issue. They included the language that a sex buyer who reasonably believes a person is underage is a violation. And the focus on the belief of the sex buyer, not the actual age of the potential victim or the presence of an undercover officer, was specifically addressed during the legislative testimony. The amendments to the statute were designed to eliminate any defense that there is no harm when the intended target is not an actual child. It is contrary to the statutory intent to treat attempts to buy sex from a police officer posing as a child as less severe than attempting to buy sex from an actual child. And I'll just get some other things that I can provide later, but Dave Pinto, in proposing a technical correction the year after, said in creating the graduated penalties based on the perceived age of the child, said that we're doing this so the way the penalty for buying sex from a minor of a given age will be the same whether there's an actual minor involved at that age or whether in fact an undercover officer is used. And then there's not a need to have an actual child involved, which is of course the best way to do this. So we can also give you other sites to the legislative history. And we also, we agree with a lot of the analysis of the paper. The part where you talk about two adults having consensual sex with each other, or an adult having consensual sex with a 16 or 17-year-old, and that some would argue that the overlay of the financial transaction would not convert it into a sex offense. Our view is that the financial transaction fundamentally impacts what is viewed as consent and is indicative of unequal positions. You acknowledge in the footnote that there's not likely the ability to have an arm's length transaction. And so we'd like the focus to be on not making a correlation between the age of consent of a 16 or 17-year-old, but to direct it to the age or direct it to the intent of the statute saying buying sex from a child at any age is wrong and exploitative. And then lastly, increased enforcement and prosecution of crimes we know falls unequally on Black, Indigenous, and other people of color, the same populations who are at the greatest risk of trafficking. We support protecting those most vulnerable to exploitation and trafficking through appropriately penalizing the serious criminal conduct, but we urge robust monitoring and oversight of the impact of the changes to ensure the law does not
sure we're muted on. Yeah, I believe we can hear you again. Uh,
Let me just,
Yeah, I was gonna say,
do
if we
that.
could just confer with if there's a member who's on the line, can you just confirm that you can hear us, please?
We can hear you.
Excellent, thank you, Judge.
thank you.
All right, please.
So let me, hang on, I
Yes.
just wanted for everybody who's listening remotely, we lost our connection for a minute, like less than a minute. But so we're back online. We stopped discussing everything as soon as we realized we lost connection. So we're back, and now we're going to be going back to our guests from the Human Rights Center, Advocates for Human Rights, and asking that you repeat what you were beginning to say before we lost the connection.
Sure, I'm not exactly sure, but the second to the last point was that the focus in age should be on the age of the person selling sex and not on focusing on age of consent where there's not a financial transaction involved. That's consistent with the intent of the statute to criminalize purchasing sex from children of any age. And then the last point, the increased enforcement and prosecution of crimes falls unequally on Black, Indigenous, and other people of color, the populations who are at greatest risk of trafficking. We support protecting those most vulnerable to exploitation and trafficking through appropriately penalizing serious criminal conduct, but we urge monitoring and oversight of the impact of these changes to ensure the law does not inadvertently increase racial disparities in criminal justice enforcement.
Madam Chair, those are all the questions. Thank you very much, Ms. Phillips and Ms. Long for attending and participating and educating the commission.
Does anyone else from the commission have questions for our guests today? So just to put a pin in it, it sounds like you would support moving the prostitution offenses from the standard grid to the sex offender grid. That's what you're saying today. Okay, all right. That's helpful. The information you provided is helpful to me. I really appreciate you coming out. I think nobody else does have questions today. So we'll get back to you if we have any others.
Great, thank you so much.
Thank you so much. Great. Okay, so the next item on the agenda is the custody status roundtable debrief. So I just wanted to, before we get started on this piece, I just want to thank everyone for attending the roundtable last week. As you all remember, the purpose of the roundtable was to continue the public conversation about how to address custody status within the Sentencing Guidelines Commission. We said back in January that we were going to be engaging stakeholders, and the purpose of the roundtable was to do that. We had some really good discussion. I thought we could spend some time talking about the things that we heard last week, and where we were talking about where we could potentially go next, go through some of those factors. The whole point of that event was for us to start to get some ideas on the table. And we've had an additional idea put on the table since then. So that's great. So let's talk a little bit about what we heard last week. And just as a reminder, that we have some interest in the topic from folks who are here today. And I just want to make clear that today is not a day that the commission is able to take a vote on an issue. We're still in the forming, and norming stage of this issue. So we're really going to be putting some ideas on the table, but today is not a day that we'll be taking any votes on anything. All right, so let's go on. As we think about back to the roundtable last week, I wanted to actually just sort of talk through a couple of themes that I heard from the folks who were in attendance, and then sort of move into talking about some of the factors that we heard that were important to people as we talk about how to address this issue of custody status. So custody status means that a person was already under supervision for an offense when they committed the current offense for which they're in for sentencing. And here's a couple of things that I heard. I'm interested if anybody has any things that they want to add to that. So I heard people around the table saying people who commit new offenses while they're on custody status for prior offenses are more blameworthy or more deserving of punishment. I also heard people saying that some offenses might pose a greater risk to public safety. And I also heard that people saying some repeat offending stems from addiction, and that may present different considerations for us, and that supervision intensity differs, both depending on the type of custody status for which a person might be under, like an escape status or being in prison and jail versus being on probation. And we talked a lot about probation and talked about how some people might be in a situation where they're receiving no services on probation, like when they're on probation to the court, or if they're under a group reporting status, or if their region doesn't have the services that they need, while other people may be receiving a lot of services. And people, I heard people saying that could make a difference to how they view that reoffense. And then I also heard that we should be mindful of the racial impact of our policy, and that our policies have differing effects on people within our community, within Minnesota, and that should be a primary consideration as we keep going forward. One thing I feel like I did not hear from anyone is I feel like I did not hear anybody really speak in favor of a one-size-fits-all approach. I heard a lot of talk about there being nuance to this issue, but that creates an issue. I think that creates tension because our guidelines are designed to bring uniformity to sentencing, and in order to do that, we usually have to create rules that can be applied uniformly in cases across the board. So we would need to be able to create a rule that takes the nuances into account if we are truly wanting to address that level of nuance. So that's why I thought it would be a good idea to talk about the factors that we heard that create that nuance last week, and just sort of explore those ideas and talk about how they affect this issue. So let's do that. The first factor that we heard, one of the factors that I heard was that offense severity matters. And actually, the custody status policy that we had at the beginning of all this, before we went down this road, before the commission in 2018 created the half point, it's all based on the severity level of the offense, right? So the half point that's in the guidelines is based on lower level severities. And in fact, Judge Larkin provided us last night with a proposal that's an example of continuing to look at the issue by offense severity. So that one really does focus on those lower level offenses. So we have in the past also considered the possibility of high severity offenses being a focus for custody status. So just the offenses that are at the top of the grid where you're always presumptively recommended for prison. But one thing we haven't talked about is that sort of middle range and whether anyone has any concerns in the middle there. So offense severity is the first factor, is one factor that we talked about. I've talked a lot already, so maybe let's stop there and just talk for a few seconds about this idea of sort of focusing on offense severity. Judge Larkin, did you want to say anything about the proposal that you provided last night? I mean, to me, that's the framing. It focuses on offense severity, but if you have a different read on that, that's fine.
No, and it's easy because it's what this commission has already decided. I mean, the commission has already said, well, we feel that these particular offenses aren't even worth a full point. So for me, it's easy to say, well, and now we've got a case that basically says, well, those aren't even going to be counted. So if we're talking about eliminating use of the custody status point for some offenses based on severity, it seems to me a natural approach to go back to the hard work the commission's already done in arriving at, the identification of those offenses, which are, the bottom two rungs and the targeted misdemeanors. Targeted misdemeanors do give me some pause because they're misdemeanors, but they're generally, DWI, that's where we see a lot of recidivism, domestic abuse, where we see a lot of recidivism. So it's not so easy to simply say, well, those are misdemeanors. In my mind, it's maybe those warrant more discussion.
Okay.
But definitely the low-level felony offenses, where quite frankly, those are the offenses where if you're going up 1 month. It really is the minimal increase to begin with as a result of the custody point.
Right. Other thoughts on offense severity from anyone else?
Madam Chair.
Commissioner Moore?
I had a question for Commissioner Larkin. So you're not proposing that we actually eliminate the half-point custody status point entirely? We would just be adopting the Court of Appeals holding that when we round, we don't count it?
I think it's not a matter of rounding. I think it does eliminate it. That's the practical impact of the Court of Appeals decision. Because with the current rules, as I understand them, the only time you're going to have somebody with a sentence that ends in a half point is as a result of the half custody point. So the Court of Appeals has said, that doesn't count. So that it essentially would eliminate it. I think the way you would write that decision into the rules is to say, here's how you get a custody point, and it would just be for these felonies and up, and probably say nothing about those offenses which we currently say warrant a half point.
Right.
So it would be, we have no more half point, and for those offenses we used to have a half point, you don't get a custody consequence. Now, that does have some downsides because you can be at a level 6 criminal history score based on felonies and you commit, this low level offense, but that would be how it breaks. And I guess it would come down to it's what you're on probation for. So if you're level 6 and you're on probation for a 5th degree possession, and then you pick up another offense, you wouldn't get a custody point because the offense for which you're on probation is considered to be a less serious offense.
Right.
And that is a very different approach because we've never done that before, and it's not about punishing the prior offense. It's sort of this notion of accountability if you've not complied with probation. But I think that's where we are currently as a result of the published Court of Appeals case. No one PFR for review on that issue. PFR was granted on another issue. So that is essentially, that's what we have now. It technically wouldn't be a change because one of two things has to happen. We have to pass a rule that says, I think one of Nate's papers, well, we meant for this half point to count for something, now it doesn't. So we either have to pass a rule kind of increasing the consequence or do nothing, or just have our rule changed to track the new reality, which is those half point offenses don't count for anything. They don't get you a custody enhancement.
Yeah, so it's just codifying reality is what you're saying. Yeah. Any other comments? What if we just continuing, like even more broadly, not only focusing, because I want to make sure all the ideas are on the table today, but not only focusing on this proposal. When we think about offense severity, does anybody have any other thoughts that they want to put out there today? Not a proposal, but like any concerns or any thoughts about offense severity that you want to make sure that we have covered today? Commissioner Middlebrook?
Thanks, Madam Chair. I think that these where we talked about kind of the middle group, if we go from the Commissioner Larkin's proposal. The middle group, I think, where my concern is with that is where the custody status point, because there's still low-level offenses, but when that custody status point pushes somebody into a prison sentence, that to me is a big concern. And so I that's where I guess I'm not sure how to exactly deal with that. But that is, I think there's still really low-level offenses in that group, because once you get up to where they're presumptive prison sentences, those are the higher level severity levels. So that's one of my concerns with the custody status point, is when it does push into, it goes over that line that it becomes a commitment.
Madam Chair,
Oh,
I'm sorry, can I just ask a clarifying question? And
Yes.
this is a question I had last week, and it's a question I continue to have this week. When we're talking about the offense severity, it's not always clear to me whether we're talking about the severity of the custody offense, which is the case in the half point, right? We're talking about how severe was that offense that got you the custody status? Or are we talking about the severity of the current offense? And so if we're talking about, these low-level offenses are the ones that only get you a month or so. Well, that's if you're talking about the current offense, not necessarily anyway, I'm just wondering if for my benefit and possibly the benefit of others, if when we're making this distinction, we're making it clear whether we're talking about the severity of the current offense or the custody offense, or maybe both. I don't know.
that is a really good point. I think I actually was going to ask something similar to that, but you said it so much better than I would have. I do think it's that's a good question. I mean, the way that our custody status is written right now, it's about the prior, right? But I think that, even I sometimes get trapped into thinking about the current offense and where that lands. So it is easy to get those two concepts mixed up. I don't know if anyone has any thoughts on that. Commissioner Ladd.
I want to back up a little bit
Yeah.
to something Commissioner Middlebrook said. I think one of the things I struggle with the idea that if someone is on the standard grid and they're at 5 points, and somehow or another their custody status point is going to trip them over that line to where it's going to be a commit to prison, somebody's worked really hard to get those 5 points. And so I don't see that as something that is either heavy-handed. I see that as maybe a failure somewhere along the way. And again, I think there's a lot of nuances here. What kind of programming, what's going on, services being offered, the formal, informal probation, current offense versus underlying offense. I think there's a lot to all those things. But I think if someone's got 5 criminal history points and they do something that triggers them to get to 6 points that now is a commitment, that didn't happen. That didn't happen because of the custody status point. That happened because of an awful lot of other things that were going on. Another thing that kind of came up, and I don't mean to repeat myself from what was discussed at the last our round table, but I know we heard a lot about that severity level 4 offense and sort of it being sort of like I think maybe the terminology that the director has used is the heat on the heat map, where we show sort of where things are triggered. And that severity level offense, well, it says non-residential burglary. There's an awful lot of violent offenses in there, and that's my word, because it's not defined by statute or by rule or anything like that. But when we're talking about domestic assaults, which people have terrible beatings and they're violent, and we're talking about assaults to children, substantial bodily harm. So you've got like you've got something, broken bone, that sort of thing. Those are severity level offenses, and to me, those are not property crimes, are not insignificant. And I just know that on the research around domestic violence, folks don't get there because they're reporting all the time. By the time stuff's starting to get reported to law enforcement and things are happening with them, there's an awful lot going on there. And so these things escalate very quickly, and I think they're very serious. And I just think that we ought not to confuse sort of that particular line on the grid, because I think that it being categorized as non-residential burglary is just sort of a a broad label, but it doesn't encompass what I would say are violent assaults that are in that category. And that leads me into a question that I had as I listened to folks last week is, when we talk about severe violent offenses and what those definitions are versus what crimes of violence are and versus, prior qualified domestic violence related offenses, those are all different things, but they're all violence and they're person violence. And I feel like that's not really being recognized in sort of this in terms of not only the public safety aspect, but also the accountability and responsibility for those offenses being committed and having consequences that are triggered as a result of that. Because with our domestic violence related offenses, for example, statute requires domestic violence programming that is lengthy and involved. And so for folks to go through that process and for whatever the reasons are, if they're not successful in that or they don't take the tools away from that not to reoffend, that's very, very concerning. And I think that's a huge public safety concern. And so I'm thinking about sort of how we're defining these offenses as well. And that was something that kind of struck me, that we have these little narrow categories, but they don't seem to necessarily grab what's really going on here from things that I see as violence that are in very severe violence. And so, so there's that point. And then to Nate's point, I actually thought about that, about this idea of somebody being subject to custody status based on what the underlying was and what the new one was, if there's a correlation between the two. And I don't have an answer for that. I think it's interesting, but again, I am sort of in the camp of accountability and responsibility for this process. And if you find yourself back here time and time again, at some point, there has to be a consequence that maybe is different than the first time offender. And that's where I struggle with, we're not treating folks the same when we are sort of eliminating this. And so anyways, those were some of my thoughts from the meeting.
Those are excellent thoughts. You hit on two things that I was going to bring up next. Other factors that I heard us talking about last time. One of them is the offense type. Like, how important is the offense type? And I heard you and others bring up violent offending multiple times, and I also heard sex offenses a few times. So I guess one of the questions is, do we have different concerns when we're talking about violent offenses, and should we be thinking about that differently? And what is the definition then? Like, which offenses are violent? Like, so is that a factor we should try to be thinking about building into a policy?
Madam Chair?
Nate.
Just to point out that there is Section 6 of the sentencing guidelines is a list of crimes for which permissive consecutive sentencing is permissible if both the current offense and the prior offense were on this list. It used to be known as the list of crime. Well, it used to just be crimes against the person, and that was deemed to be too vague, so the commission made this list. So so that is a potential starting point for this discussion, is just to say, is this offense or is the previous offense or both offenses on listed in Section 6?
That's right. I forgot that used to be called person crimes, basically. Yeah.
And I think that still is sort of what it's trying to be.
Mm-hmm. Yep. And I also heard you talk. The other sort of interrelated factor that I heard was repeat offending. And so then when we think about repeat offending, I think the question is, are we equally concerned about any kind of repeat offending, or meaning that they committed any crime in the past, they've committed any crime in the future? Or is there more concern about repeat offending with the same type of crime, or when we think about the offense type or whatever the crime was specifically? I'm not sure if anyone has thoughts around that as well.
Madam Chair.
Commissioner Moore.
Repeat offending is a serious problem. We've heard this, it's obvious. And the type of repeat offense, I think, does make a difference. I mean, if we're talking about person crimes, we're talking about violation of court orders, car theft, carjacking, things that, you know, people see and people feel and experience, maybe as opposed to other offenses that might be more administrative or technical. And I think some discussion about the issue that Director Wrights just mentioned, the list for, you know, permissive consecutive sentences. I think one thing that came through to me is the amount of additional time that a custody status point is perhaps given is really maybe not enough in certain circumstances. You know, if the offense isn't on the permissive consecutive list, maybe it should be. But I think repeat offenders who are consistently doing the same type of criminal activity, I think that's materially different than somebody who is on paper for an offense and commits some completely unrelated offense, potentially like some type of non-person, non-violent, you know, theft offense or something like that. I mean, it seems to me that there is a difference. And, you know, I think we should be recognizing that in this discussion.
Any other thoughts? I also, that discussion also, I think that discussion and Nate's suggestion that we look at list 6, I can't remember, that's what it's called or not, but also brings up this whole idea. I did also hear people talk about consecutive sentencing last time as well. And we know that the way presumptive consecutive sentencing works right now, we already have it in place that if you're on escape status or serving time in prison and the current offense is commitment, that can be presumptively run consecutive to your prior offense. There are, you know, more limits on other types of reoffending. So I think I heard someone last week also talk about, you know, are there any tweaks to consecutive sentencing we should consider, or are there offenses we might need to add to the list for consecutive sentencing? So I think those are also factors that could be discussed. I just want to recognize that was brought up. Commissioner Middlebrook.
Thank you, Madam Chair. I'd also, I mean, if you look at the list for the permissive consecutive sentences, it's pretty expansive. There's also the provisions on the severe violent offender that does take into account repeat offenders, that increases those sentences for those in that list. And this permissive consecutive sentencing list is a lot broader than that severe violent offender list too. I just wanted to note that.
All right. And the only other factor that I heard last week that I don't think we've talked about today is supervision level. So that came up as well. And so I heard, I think at least one person at the roundtable said, you know, if you're in prison or on escape status, when you commit the new offense, that's much more serious. That's the most serious. And then, you know, there might be a sort of continuum of seriousness depending on the type of custody you're under and depending on sort of how much engagement you've had by the criminal justice system. So whether you really had the services you needed to change your behavior or not. That was brought up last week as well. Anything else that anyone wants to add there? Commissioner Lett?
Thank you. I think that, you know, I listened to that, and I think it was the representations from the probation folks that sort of talked a lot about that. And I would just say that I think that is a geographical issue, because you don't see a lot of probation out in greater Minnesota that you have supervision to the court. You just don't. They're either supervised, and there's different supervisions. There's low, medium, and high, and that really means how many times they meet. I think low supervision is you meet 4 times a year, so quarterly. So there's and I'm saying that from a community corrections probation county. But we don't do probation to the court. That isn't a thing. And so, and I know that came up and that was something that was talked about. And I know that in a lot of smaller counties, that's not a thing. I think you have a staggered sort of supervision level that's, you know, more intense versus less intense. And you're actually on supervised probation, but we don't have informal probation or unsupervised probation of the court. That isn't a thing. And so it probably is a different issue because I know we have, I think, 3 different types of probation entities in Minnesota. And so I think in terms of how probation is administered across the state is, again, we're not going to fix that here, but recognizing it isn't the same. So maybe what's happening down in, you know, Hennepin isn't what's happening up in Cook or in Wadena or even in Clay. So I think that's to me, that's a harder thing. And so to try to put some parameters around what would be those different levels, because they don't sort of translate across the board easily, I think is to me a sort of a harder challenge for this group, seeing how it actually works in practice.
Yeah, I actually share Judge Larkin's concerns about the types of factual findings that might be necessary to think about supervision in that way, because there is so much variation. And to me, that doesn't lend itself to a rule very well. It lends itself more to judicial consideration. So I also, while I recognize those differences, I also find that challenging, and it makes me, you know, want to think of a simpler solution.
Well, I just think that one of the, pardon me, I think one of the things that it creates is, I think it disproportionate sentences and consequences across the state. And our goal really is to have uniformity and not to have those, you know, wide-ranging disparities in similar sentences across the state because of that particular factor. I would be very, very concerned about agreeing to do anything that we would say leave it open-ended that way, because I don't know what that would look like. I mean, from a practitioner's perspective, I don't know how that would even function.
Do you have a comment, Judge?
No, I agree with those concerns.
Okay. Any other comments on that?
I also agree with those concerns. It's not as simplistic as we'd like for it to be. And I do agree that there'd be disparities across counties based on resources and how departments of corrections and operate and what they do.
Any other comments, sir?
Madam Chair, this is Knutson.
Commissioner Knudsen.
Yeah, I think when we get in, we were talking about how nuanced some of this is. And, you know, a lot of that nuance is argued and taken into consideration at the time of sentencing. That's why we have the ranges in the guidelines and all the rest of that. And if we start trying to codify or create descriptions of all those nuances, I think we're just digging ourselves into a deep hole, making it worse as far as uniformity and of the application of the guidelines.
Yeah, I think that's a really good point. I mean, there were a couple of times during the roundtable last week where I had a similar thought, and I thought, you know, these are, some of these issues are so complex that, you know, I think it would be well with a good use of judicial resources to think about where in the range does this sentence fall as a result of that factor, right? But I don't know that that's a factor we should be creating a rule for. So I often felt that way as well. The only other factor that that we talked about last week, that it's different in nature, would be the racial impact of custody status. Professor Wrights walked us through if we had pursued the high severity limitation before, for instance, he walked us through what the racial impact of would be, how the racial impact would change for imprisonment rates for people who are Black and Native American especially. And so, that's the only other factor that I think about I think that we should be just thinking about as we go. To what extent does custody status have a disparate impact on populations in Minnesota? And to what extent do we want to take that into consideration as we continue to consider what the fix is for this issue and what the impact of any change that we make would be? I think we need to be mindful of that. Are there other factors that people heard that we haven't brought up today that we should be talking about? No? All right. Well, we have a lot to think about, I think. I think we have a lot of different thoughts on the table. I really appreciate, Judge Larkin, that you submitted a proposal for us to consider. I think that's a great starting point. And I think that, we have a little bit of time to digest the themes and the factors that we heard between now and our next meeting. And if anybody else has a specific proposal as well that they would like us to consider in the fall, then I think the next meeting would be a great time to bring that forward. Your proposal will definitely be on the September agenda as well. Does anyone have any other thoughts that we want to talk about today? Commissioner Moore?
So more of a process question. Is your hope that we might be able to come to some final vote on this in September, or would that be something that we would want a public hearing for if we have multiple proposals?
Yeah, so we can't, so first of all, we have rules in place about the process and how it works for the commission. So we can't take a vote on any particular proposal until it's come to the commission at least twice. If there are other proposals that come next month as well, then I would think we'd want to sort of do something similar to what we did last fall, which is talk about the merits of the different proposals that have been put forth and sort of figure out, what are the pros and cons of the different proposals. Once we have had something in front of us at least 2 times, then it can become an action item, and we could potentially act on it. After we act on it, the action is to send it to a public hearing, and for us, that usually occurs at the end of the year, and then once it goes through public hearing, then we can potentially include it in our reports to the legislature if we come to a final decision on that. But I would think that this fall, we're going to need to wrap up the prostitution and sex trafficking review, and I would hope that we would wrap this issue up as well. Any other thoughts or questions?
Can I just be a bit more specific as far as putting names to those meetings? So basically there are 3 meetings, kind of bump set spike is kind of how I think, right? So September is figure out what you want to talk about. We can certainly bring forward some possible language to codify Bogdanovich basically, and since that's been proposed, and you can deal with that. But October really should be when proposals are. That's kind of the deadline for bringing proposals and discussing them, and then November is the deadline for actually taking action. So November is the action date, because at that point a proposal has to be submitted to public hearing, and then the meetings would be. The December meeting would be also a public hearing at that point, or maybe primarily or exclusively a public hearing at that point. And then And then the final action would occur in January, immediately before the publication of the report to the legislature, assuming the commission wished for these changes to take effect August 1st of 2023.
All right. All right, well, if there's nothing further on that, why don't we move on to item 7, which is, are we gonna publish a set of 2022 guidelines or not?
Thank you, Madam Chair. So staff, we kind of talked about this. We think it would be easiest on practitioners to publish 2022 guidelines, even though there aren't really any changes. The changes would just pretty much be changing 2021 to 2022 and adding a couple of new commissioners to the title page. That would really be it. But basically, I think just about every year since the beginning, we've always published an annual set of guidelines. And I think people would find it confusing if they're looking for the 2022 guidelines, that there aren't any, they have to refer to the 2021 guidelines. So, unless there's, any, obviously it's not a big deal either way, but we just think it'd be easier on practitioners. So unless you object, I guess we'd like to go ahead and publish the August 1st edition of 2022. Republish basically the 2021 guidelines.
What did commission members think?
We republish the rules every year, even though they don't change, but that's not really us, that's West, right?
Right.
Mm-hmm.
I mean, I'm just thinking, like, I get a new rule book every year,
Right.
nothing's changed. But we don't generally cite the dates for the rules, right? Commissioner Middlebrook, I mean, do we ever have a situation where we're like, well, this is the legal issue and it happened in this year, so we have to go by that rule? I mean, we do it for sentencing.
Right.
But for procedural rules, do we do that, or do we generally just say the current rule controls? When there's been a change in civil law, we always say the current controls.
The only thing I can think of is where they did all those technical changes to, well, not technical, but they changed those dates for kind of in the middle of, the middle of the year. So like it went from 5 to 7 days and 10 to 14. So they had 2 provisions in there when it was effective. That's the only thing I can think of with those rules that came up that way. But they just did that all in the, West just did that to show the 2 different time periods. It was confusing, but.
If you're dealing with sentencing though, you have to be sentenced under the laws in effect at the date of your offense.
Right.
And so if we're talking about sentencing 2022 offenses and there's no 2022 guidelines to cite to, that might throw people off, right?
Well, and I will say that it used to say on the cover of the sentencing guidelines that these guidelines are in effect on August 1st, 2020, whatever, and remain in effect until the next annual publication of the sentencing guidelines. And I actually was like, well, we don't have to publish. There's nothing written in the law that we have to publish every year. So we actually changed that language. You actually changed the language on the cover so that it doesn't require us to publish every year. So there's no requirement to publish every year, but I still think people kind of get used to it. So it's almost more of a psychological thing. I don't know.
Commissioner Middlebrook.
Thank you, Madam Chair. I think you'll get a ton of inquiries, where's your 2022 sentencing guidelines and commentary as soon as they pull up the website and it says 2021.
Right.
I think you'll get tons of, where are they? So I would say, go ahead and republish.
Not hearing any objection.
I don't think we care.
Okay. Well,
Just there costs or?
no, it's all digital.
More.
Yeah, we don't.
So like we're saying we're gonna publish it, but it's really pushing it back. There's no paper.
Yeah, there's no paper.
Do you need are you comfortable
Formal
with that?
vote.
Yeah,
Do you need
I
a
mean,
vote?
I guess I'm letting you know that that's our intent. I mean, we certainly could do a vote, but it's not on here as an action item.
Actually, it is.
Is it? Oh, okay.
Mhm.
Sorry. Yeah, I guess we'd like a vote.
Do we have a quorum?
We do.
Oh.
We have, I think we have 9 here today. Yeah.
Right.
So Commissioner Middlebrooks?
Thank you, Madam Chair. I'll move to have the 2022 republication of the guidelines and commentary.
All right, so we have a second. Commissioner Larkin seconds. Any comments on the motion? Discussion on the motion? Hearing none, let's go ahead and vote on that.
To the Middlebrook motion to republish the Minnesota Sentencing Guidelines and Commentary on August 1st, 2022. Estrada?
Yes.
Estrada, yes. Hansi? Hansi, no response. Ibrahim? Ibrahim, absent. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell? Schnell, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Have fun putting 2022 on the cover.
Thank you. Well, and 2 new commission members, so.
That's right. That's right. This is true.
All right.
So next item on the agenda is the fiscal year 24-25 budget change requests. Is that right? Isn't it 20? Oh, yeah, that's right. We're in
Yeah.
23 right now,
Which
aren't
is,
we?
yes, we're a month into fiscal year 23 right now.
Okay.
It's
I hate fiscal years. They're so
it is,
confusing.
I know. I have to
Okay.
think about it 3 times.
All right, why don't you go ahead and explain?
Thank you, Madam Chair. So just on a personal note, I started working for you 8 years from next Sunday. So that means that this will be my 5th even numbered fall. And the significance of the even numbered fall is that that's the time when Minnesota Management and Budget asks agency directors if they had, or commissioners of departments, if they have any changes that they'd like to make to their budget. And then, so the process is those change requests are forwarded to the governor through Minnesota Management and Budget, and ultimately are made part of the governor's budget request. And in the case of every other even numbered year, potentially it's a new governor, a new administration that looks at those agency change requests and incorporates them or doesn't incorporate them into the gubernatorial budget. That's then submitted to the legislature on the odd numbered years in January, and then the legislature considers those, passes a budget in the odd numbered years, and then it takes effect on July 1st of the odd numbered years for the next 2 years after that. So that's why this is fiscal year 24, which starts July 1st of 2023 through fiscal year 25. So it's a biennial budget cycle. So in the previous 4 falls, I have not asked for a change item. Well, unless it was just because, the costs of inflation were exceeding the budget that we had allotted, and we just needed more money to pretty much do the same thing with the same resources that we had always had. This year, I am considering making a change request to Minnesota Management and Budget, and I don't have that for you today, but I do believe it is going to involve a new staff member, and I'd like to have some time on the September agenda, Madam Chair, if I could, to describe this in detail. There's 2 reasons why I'm bringing it to your attention. One is from an internals control point of view, sort of a good governance point of view. You are the oversight body of the agency, if you will. I know in some senses you are the agency, you're the policy making body, but as far as the money is concerned, that runs through me and through the staff, and almost all the expenses are the staff, but also we have an office and we have other expenses. But you are the oversight body over me. And Madam Chair, I know you're personally involved in internal controls documents every year. But in that internals control environment, you are the supervising board. So I'm accountable to you to when I make decisions like this. So I do want to bring it to your attention for that reason. Another reason is that the charter statute Vice Chair Estrada, can you confirm that you can hear us?
I can now.
Okay, thank you.
All right, once again, we lost our connection, so I apologize for those who are listening remotely. We stopped talking once we lost the connection. And we're gonna have Nate pick it up where he left off.
Thank you, Madam Chair. I apologize for that. I think this happened at one other meeting in this room, but it's happened 4 times today, so I apologize. And I for those who are curious, if you want to see what happened in the interim, you can look at the meeting on the website, and I think it'll tomorrow probably, and on the YouTube page, and it should have the entire meeting. So there shouldn't be any periods in the blank. Okay, so I was talking about the reasons for bringing it up. One is the internal controls model, where you're the governing body and I'm accountable to you. The second reason is that the statute, the charter statute 24409, specifically says that the commission may hire a research director and other and clerical and other staff that the commission may approve. So I think that the commission may approve language implies, at least to me, that there's a role that you have in determining the size of the staff. So if I'm looking at needing an additional staff member, then I think that should go to you under the staff. So I will be bringing this to you next time. It just sort of a preview of what we're looking at. The issue having, there's really 3 issues. One is the issue having to do with the staff, has to do with things that we're not doing now that we could and probably should be doing. I'm a bit in a state of flux exactly how I'm thinking about this right now, but I know that there are, kind of large warehouses of data that we are collecting right now that we just don't have the resources to do anything with. There's also additional data that we don't collect and that we could possibly do something with as well. But I think if we're just going to keep our goals more modest, we could certainly look at, what about data that we're getting now that we just aren't processing that could be useful to you as the commission, could be useful to policymakers, that I'd like to take a look at. So I'm going to refine that a bit more and bring that to you. But that might be taking the shape of a research supervisor. So one level higher than any research staff that we have right now, who I think could help us look at that and really help the output, our data output that we put out, our data reports, both for your benefit as the commission and for the benefit of the legislature. And another part of that is, I don't know if you've noticed it, but every time the commission has a big research project for us, our wheels come to a stop. Every time the legislature starts coming in with fiscal notes, our wheels come to a stop. And if somebody resigns, our wheels come off, basically. We're just unable to do anything. So I think we need a little bit more breathing room on the personnel side, and specifically on the research side of the house. The second general area that I'm looking at asking for has to do with our relationship with the Department of Corrections. Right now, we receive essentially for free, although there's technically supposed to be a barter services agreement, but we receive human resources and accounting services from the Department of Corrections, which is very nice of them, but that's really not the way it's supposed to work in a good governance model. We're supposed to pay for what we get. And there is an agency that's job basically is to provide human resources and accounting services to small agencies such as ours. It's called the Small Agency Resource Team, but they do charge, as they should, and that would be sort of the second ask that I'd be looking at in our potential change request this year. And the third item has to do with, and this is still to be fleshed out, but we definitely have some room for improvement on a database management side. There's some very frustrating things about how we currently handle our data, just from an IT point of view, and how we integrate with other entities and process that data. And I think that could be improved. So that would be our third area. But those are kind of the things that I'm looking at modernizing. And I should say that the Commissioner of Corrections, our current Commissioner of Corrections, we don't know that it'll be next year's Commissioner of Corrections, has a very interesting ask as far as integrating different criminal justice information systems. And, but we're very fascinated by that. We'd like to get on board on that. That was some of what I was thinking about asking for, but I think it's probably better being done from a larger agency. So I think for the most part, we'd be piggybacking on that. So I know you wanted to keep this meeting short, so I'm gonna keep you in suspense as to the details on that until September. Give you a chance to come. And Madam Chair, just to jump ahead, I think pretty much everything I've already said has been encompassed in the Executive Director's report, other than that the National Association of Sentencing Commissions annual conference is coming up in a couple of weeks. And I will be seeing some of you there.
Yeah, who's going from the commission again?
It's, okay, yeah, so it's Commissioners Ladd. I have a spreadsheet in which that determines the order in which I ask people, but I believe it's Commissioners Knudsen and Ladd and myself and Senior Research Analysis Specialist Jill Payne. And I think you're coming, but on your own dime.
I'm coming at my own dime.
Well,
Anybody else
on your
going?
employer's
Or is
dime.
it- Huh?
On your employer's dime, I trust.
That's true, it is my employer's time. It's part of my job. All right, is that it? Is that everybody that's going? All right, good to know. Okay, so you have nothing further for the executive director report, is what you're saying, or do you?
I don't.
Did anybody have any questions for Nate on the budget before we leave that item? I'll just say for the record that I support your efforts to seek additional funding. We had a discussion earlier this year where you were struggling to complete the racial demographic impact notes, and that's a staffing issue, and I really think it is important that we're meeting all of the responsibilities, so I would definitely support taking the time to make that budget request this year. All right, I guess if there's nothing further for the executive director's report, then we're moving on to public input.
All right, so if there's anybody who's here in the room who would like to make a statement, I think probably one of those two chairs over there would be great to sit in. For folks who are online, you can raise your hands. So I see that, for members of the MSGC staff who are online, if you could please raise your hand so I know that the hand function is working. All right, so if you do want to make a statement, please raise your hand. I don't see any hands being raised other than staff. Staff, if you could just keep your hands raised. All right. So I don't see anybody in the room who's interested in making a statement, and I don't see any hands being raised by the public. But staff, please keep your hands raised so I can see that. There is one telephone caller who won't be able to raise their hand, so I'm going to unmute that caller. So it's a 218-966 number. Just to warn you, I'm about to unmute you. All right, caller, you're now unmuted. Do you wish to tell anything to the Sentencing Guidelines Commission today?
Oh, hi, this is Michelle Hitzeg again. I'll keep it real short because I know you guys want to get out of there, and I don't blame you. The last meeting was pretty lengthy. Thank you again, and it was very informative this time, and I just want to say that I very much so concur with the whole statements about with the point system really needs to reflect more the violent. I think that's what the public is concerned about is the violent offenders and the repeat violent offenders. So that portion was very interesting and very good, but that's, I guess, all I have to say. I sent in stuff to you guys, and I'm not going to keep you. So have a good day. Enjoy your day.
Thank you very much for your
Thank
comments.
you.
All right. Is there anybody else? Are we?
No, that's it, Madam Chair. Apparently no other members of the public wish to make a comment.
Okay, then we have with that we have reached the end of our agenda today. I promised I was going to keep it short, and I actually came through with that for once, so I'm excited. Thanks everyone again for a really fabulous roundtable last week. It was very informative to me. I hope it was informative to all of you as well. Thank you for coming back today so that we could debrief that experience. We are off for August as usual. So we don't have a meeting next month. We normally have that, so the staff actually gets a little break, and then NASC always happens in August, so that's part of the reason why we usually don't meet that month. Our next meeting is in September, but I don't know the date.
It's the Thursday, I think it's the Thursday after Labor Day.
Thursday after Labor Day.
Yeah.
All right, so we will meet again in September, and with that, we are adjourned. Thank you.